Good morning, everyone. Welcome to this session. How are you feeling today? Firstly, I'd like to welcome you to Unacademy, India's largest online learning platform that provides to you a world of courses, resources, content, live and recorded sessions to help you in your preparation for the CA Foundation and Intermediate examinations. And then I would also like to welcome you to crack CA exams with us, which is a vertical and channel of Unacademy that caters to the students of CA Foundation and Intermediate in their journey and pursuit of preparation for the CA Foundation and Intermediate examinations by providing top educators, quality content, and overall a great learning experience. So come, let's crack CA exams with Unacademy, India's largest online learning platform. Welcome to the session once again. Now, before I proceed, there's a brief introduction about the educator. Hello, I'm Prathik Gupta. I am a Bachelor of Commerce from Christ College, Bangalore University. I am an associate member of the Institute of Chartered Accountants of India, an associate member of the Institute of Cost Accountants of India, an associate member of the Institute of Company Secretaries of India, and also a law graduate from Karnataka State Law University. I am currently a practicing chartered accountant and also a visiting faculty for CA subjects and an educator for students, CA students, both offline and online. Prior to starting on my own, I worked with SR Bartley Boy & Associates, that is the Indian member firm of Ernst & Young Global in the Audit and Assurance Department, and then I went on to work for EY India, Ernst & Young India in the Mergers and Acquisitions Department, and then finally I went on to work for the Manipal Group in Bangalore as the corporate controller of their Indian entity as well as their German subsidiary located in Frankfurt, Germany. And it was only after I got back from Frankfurt, Germany that I decided to start something on my own. And that gave me an opportunity to become an educator, which in turn has given me this opportunity today to be able to take this session for you young, bright and enthusiastic CA aspirants. Thank you so much for giving me this opportunity, and I really hope you find the session useful. Anytime during the session, in case you have any questions, queries, observations or discussions, please feel free to drop in a line and I will be happy to take up the matter for problem solving or for discussion purposes as the case may be, as soon as possible. Also, I'd like to draw your attention to my name and the spelling of my name. My name is Prathik Gupta and it is spelled as Prathikgupta. It's Prathik with an H. Now, why I'm stressing on the spelling of my name is because a lot of people miss the H in my name because of which it is misspelled, and hence they do not find my numerous sessions on the YouTube channel of Unacademy as well as the special classes on the Unacademy Learning app. So you can look me up with my name, that is Prathik Gupta, Prathikgupta, and you will find the number of sessions on the YouTube channel of Unacademy as well as my special classes on the Unacademy Learning app, which will help you in your preparation for the CA Foundation and Intermediate examinations. Moving on, like I told you, Unacademy caters to you in your preparation for the CA Foundation and Intermediate examination. It does so through 3 platforms. What are those 3 platforms? The 3 platforms are YouTube, Special Class and Plus. Now, YouTube and Special Classes are absolutely free of cost, but they provide you a tremendous amount of value and resources to help you in your preparation for the CA Foundation and Intermediate examinations. YouTube is what you're watching right now, where you just need to go onto the YouTube channel, type in Prathik Gupta, and you can see the hundreds of hours of special classes that I've taken there. Special classes are available on the Unacademy Learning app, and they too are absolutely free of cost, but they provide you valuable amount of resources to help you in your preparation for the CA Foundation and Intermediate examinations. And then coming to the Plus platform of Unacademy, the Plus platform of Unacademy is the premium platform of Unacademy that is a payment-based subscription model and which provides various subscription packages to you. And more about the packages in the following slides. But in this slide, I will tell you quickly as to why I recommend and encourage you to become part of the Plus platform of Unacademy as soon as possible. The first reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the daily live classes it provides, where you get to chat with your educator, engage in discussions, ask your doubts and answer polls, all this while the class is going on. The second reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the live tests and quizzes it conducts on a regular and periodic basis, which helps to evaluate your preparation and also get a detailed analysis of your performance, which is important for any professional examination. The third reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the structured courses it provides, as all our courses are structured in line with your exam syllabus to help you best prepare for it. And lastly and most importantly, the reason why I recommend and encourage you to become part of the Plus platform of Unacademy is because of the unlimited access it provides, where one subscription gets you access to all our live and recorded courses to watch from the comfort of any of your devices. So keeping all these advantages in mind, among many others, I strongly recommend and encourage you to become part of the Plus platform of Unacademy as soon as possible in order to accelerate and enhance your preparation in the CA Foundation and intermediate examinations. Let's move on. Now, in the previous slide, you heard me say live and recorded Plus courses and live and recorded special classes. So you might be wondering where they are available. So let me tell you that all your live and recorded Plus courses and live and recorded special classes are available on an app known as the Unacademy Learning app. So for all of you who have downloaded the Unacademy Learning app and are using it, I thank you very much and I request your support in the future as well. For those of you who have not yet downloaded the Unacademy Learning app, I request you to go to the Play Store on your mobile phones, download the Unacademy Learning app, install the Unacademy Learning app on your phones, put in your mobile number where you will get an OTP, and using that OTP you can register on the Unacademy Learning app. It is as simple as this with no lengthy or complicated procedures. So now your next question might be, okay, you've downloaded, installed and registered on the Unacademy Learning app, so what's next? So let me tell you that the Unacademy Learning app gives you access to all the live and recorded special classes that Unacademy has to offer to you to help you in your preparation for the CA Foundation and Intermediate examination. And it also offers to you all the live and recorded Plus courses that Unacademy has to offer to you in order to accelerate and enhance your preparation for the CA Foundation and Intermediate examinations. So keeping these points in mind, I request you to download, install and register the Unacademy Learning app on your phone so that you can make use of the world of resources that Unacademy has to provide to you to help you in your preparation for the CA Foundation and Intermediate examinations. Alright, let's move on. Now, coming to the important slide. Now, like I told you, the Plus platform of Unacademy is the premium platform of Unacademy, and that is a payment-based subscription model and which provides various subscription packages for the various examinations. Accordingly, the packages provided by the CA Foundation and Intermediate subscription packages courses are as follows. The packages provided are for 1 month, 3 months, 6 months, 12 months and 24 months. The 1 month package will cost you rupees 3,500. The 3 months package will cost you rupees 8,750. The 6 months package will cost you rupees 14,000. The 12 months package will cost you rupees 17,500. And the 24 months package will cost you rupees 21,000. Now please remember, all these are the list price of the packages. So before you make the payment for the package of your choice, please do not forget to use the code Prathik to get an instant discount of 10% on the above listed price. I repeat, please do not forget to use the code Prathik, Prathik, that's me, to get an instant discount of 10% on the above listed price. The after discount price of the various packages are as follows. The 1 month package will cost you rupees 3,150. The 3 month package will cost you rupees 7,875. The 6 months package will cost you rupees 12,600. The 12 months package will cost you rupees 15,750. And the 24 months package will cost you rupees 18,900. So you see, you're getting a savings or discount of 10% immediately when you use my code Prathik. Now, I will personally recommend you to start off with the 12 months or 24 months packages for 2 reasons. Firstly, it is cost effective. If you compare the 1 month package cost with the per month cost of the 12 months and 24 months package, you will see that you're getting great cost savings almost immediately. And secondly, and most importantly, since the CA Foundation and Intermediate course is provided to you in one package, that is 12 months or 24 months, a 12 months or 24 months package will be highly beneficial to you because it covers the duration of both your courses, that is your CA Foundation and Intermediate, which normally take a minimum of 12 months for you to prepare and clear. So if you're getting a package that is 12 months or 24 months covering the entire duration of both your courses, CA Foundation and Intermediate, at a very cost-effective price, I think that is a very good deal. But having said this, you're free to choose the package of your choice. But before you make the payment, please do not forget to use the code Prathik to get an instant discount of 10% on the above listed price. You can also make use of the no-cost EMI options available for the 6 months, 12 months and 24 months packages, just in case you do not wish to make the entire payment at one shot. The payment options available to you are internet banking, debit card and credit card, and also all the coins that you accumulated by watching the special classes can be redeemed while making the payment for the Plus courses. So keeping all these packages, incentives, discounts in mind, and also the advantages I told you a couple of slides earlier in mind, I strongly recommend and encourage you to become part of the Plus platform of Unacademy as soon as possible in order to accelerate and enhance your preparation for the CA Foundation and Intermediate examinations. Like I told you, the Unacademy Learning app gives you access to all the live and recorded special classes Here are the snapshots of few of the many special classes that I have conducted on the Unacademy Learning app, which you will find useful in your preparation for the CA Foundation and intermediate examinations. There are special classes on revision test papers, Sale of Goods Act, Indian Contracts Act, the Companies Act, Fundamentals of Accounting, Retirement of Partner, Admission of Partner, Death of Partner, Valuation of Inventories, Revision on Final Accounts of Non-Manufacturing Entities, and Revision on Sale of Goods or Approval or Return Basis, and many more. So all you need to do is log into the Unacademy Learning app, go to my profile, Prathik Gupta, and start making use of the hundreds of special classes that are there on the Unacademy Learning app exclusively for the benefit of the CA Foundation and intermediate students. Also, here are the links to few of the many special classes that I have conducted on the Unacademy Learning app. You can either click on these links or copy and paste these links on your browser to take you directly to the Unacademy Learning app. There are special classes on the Indian Contracts Act, Sale of Goods Act, the Indian Partnership Act, the Limited Liability Partnership Act, the Companies Act, Basics of Communication, Accounting Concepts, and revision test papers, among many others. So like I told you earlier, please log into the Unacademy Learning app, go to my profile, Prathik Gupta, so that you can start making use of the world of sessions that are taken there exclusively for your benefit. Okay, so let's start off with the Doctrine of Indoor Management. This comes under Companies Act 2013, and this is a very important doctrine or question from your exam point of view as well, because this is quite frequently asked. Now, before we go into the doctrine of indoor management, we need to understand how it evolved. Please remember, the MOA and AOA are the most important documents in a company, and as per Section 399 of the Companies Act 2013, the AOA, Articles of Association, and the Memorandum of Association are public documents. That means anyone who wants can obtain a copy from the ROC by paying a nominal fee or from the company. So any person who is intending to work with the company or start operations with the company is expected to know the contents of the MOA and AOA, and then later on he cannot use the excuse that he did not, because these are public documents. He is assumed to have read the MOA and AOA and also understood the contents of the same. So firstly, we had a doctrine of constructive notice, and from the doctrine of constructive notice, doctrine of indoor management originated, because of the drawbacks of the doctrine of constructive notice. So we will look at what is the doctrine of constructive notice first, and then how slowly the doctrine of indoor management evolved. Okay, anytime during the session, in case you have any questions, queries or observations, please drop in a line and I will be happy to take it up for further discussion of a problem solving as the case may be. So let's have a look at doctrine of constructive notice or knowledge first, because your doctrine of indoor management has originated from the doctrine of constructive notice. Every outsider dealing with a company is deemed to have notice of the contents of the memorandum and articles of association. These documents on registration with the registrar assume the character of public documents. This is known as constructive notice or memorandum and articles. Okay, so like I told you earlier, the memorandum and articles of a company are considered as two of the most important documents in a company. While the memorandum deals with the external relationship of the company, the articles of association deals with the internal relationship of the company. So on incorporation of a company, every person who's planning to incorporate a company is supposed to submit an AOA and MOA to the ROC for registration, and if the ROC is convinced or he thinks everything is in order, he can approve the MOA and AOA. And once he approves the MOA and AOA, they become public documents. They become public documents means either you can go to the company and ask for the AOA, MOA, or you can go to the ROC, pay a nominal fee of 50 rupees or 100 rupees and download the copy of the AOA and MOA. So this fact that it's a public document means it is known as the constructive notice of memorandum and articles. That means any person who deals with the company, this any person could be a vendor, he could be a banker, he could be a customer of the company, who deals with the company is presumed to have taken a copy of the MOA, AOA and read the contents of the MOA, AOA and also understood the contents of it, and only then they go on to work. Now, why is this important? Because there is another doctrine in Companies Act, the doctrine of ultra vires, which means that if the company does any act which is not mentioned in the object clause of the Memorandum of Association, then such an activity will be considered as ultra vires the company or ultra vires the memorandum, and such an act cannot be enforced against the company. So it becomes very important for anyone dealing with the company to first obtain a copy of the MOA, AOA, read the contents of those, understand it, and only then enter into a transaction with the company. Because if they enter into a transaction with the company without reading the MOA, AOA, and later on it was found out that the activity was not mentioned in the object clause of the Memorandum of Association, then that such a contract is not enforceable against the company, and the outsider who has dealt with the company will have no remedy. So if the company owes him any money, it's gone. The court will simply ask him, because ultra-wise, did you read the Memorandum and Articles of Association? If he says no, that's the end of it. There is no other discussion. So to avoid the concept of ultra-wise, you need to have knowledge or have read the MOA and AOA and gone through the contents of the same. The Memorandum and Articles are open and accessible to all. It is the duty of every person dealing with the company with respect of these documents to see what is within the powers of the company to enter into the proposed contract. So please remember, first we are understanding what is ultra-wise, then we are understanding the doctrine of constructive notice, and then we will see how the doctrine of indoor management originated. So before that, you need to know this. Okay, please take 2 minutes, go through this. Any questions, please ask me. Please take 2 minutes. Any questions, please ask me. Any questions, please ask. Are we done? Alright, so let's move on. Now, Section 399 of the Companies Act provides the inspection, production, and evidence of the documents kept by registrar. It provides that the memorandum and articles, when registered with the registrar of companies, becomes a public document, and when they can be inspected by anyone on payment of a nominal fee. So, like we said earlier, Section 399 of the Companies Act declares the Memorandum and Articles of Association as public documents, and any person can inspect, produce, or keep them as evidence of documents kept by the registrar on a payment of a nominal fee. So it provides that the Memorandum and Articles, when registered, so like I said, once you're in corporation, you register your Memorandum and Articles with the Registrar of Companies, or when subsequently you make any alterations in the Memorandum and Articles of Association, you are required to register such an alteration with the ROC. So such altered AOA and MOA also become public documents, and they can be inspected by anyone on payment of a nominal fee. Okay. Therefore, any person who contemplates entering into a contract with the company, be it a vendor, a customer, or a banker, has the means of ascertaining and is thus presumed to know the powers of the company has, and the means of ascertaining and is thus presumed to know the powers of the company and the extent to which they have been delegated to the directors. In other words, every person dealing with the company is presumed to have read these documents and understood them in their true perspective. This is known as Doctrine of Constructive Notice. So basically, the Doctrine of Constructive Notice means any person dealing with the company is presumed to have read the documents and understood them in the sense that they think. Now this I found a little bit of a drawback, because see, a normal person like you and me are doing CA. So for us, it's okay if we read the Memorandum and Articles, we will understand what it means. But for another common man or layman, it may not be possible for him to understand. He might read the MOA and AOA, but how is it possible for him to understand the content of the AOA and MOA? So then for them it can be a little harsh. Okay, please take 2 minutes, go through this. Any questions, please ask me. Any questions, please ask. Please take 2 minutes. Any questions, please ask me. Let me know once we're done, please. Take another minute. Are we done? Okay, let's move on. Now, the Memorandum of Association and Articles of Association are the two most important documents needed for registration and incorporation of a company. The Memorandum of Association of a company contains the fundamental conditions upon which the company has been incorporated. So basically, your Memorandum of Association contains 6 clauses. Your name clause, your address clause, your object clause, your capital clause, liability clause, and your subscription clause. Okay. So basically, the name clause contains the name of the company as whatever it is, ABC Private Limited. The address clause contains the state in which the registered office of the company is situated. The object clause is the main clause under the Memorandum of Association that gives the main activities that the company is expected to carry on. The capital clause contains the authorized capital details of the company as to what is the authorized capital of the company, broken up into how many shares of what nominal amount each. And then you have the liability clause, which says what is the liability of the members of the company, whether it's a company limited by shares, limited by guarantee, or an unlimited company. And the subscription clause, where the subscribers to the memorandum undertake to take over the number of shares subscribed against their names. Okay, so the Memorandum of Association and Articles of Association are the two most important documents needed for registration and incorporation of a company. The Memorandum of Association of a company contains the fundamental conditions upon which the company has been incorporated. According to Section 256 of the Companies Act 2013, defines the memorandum means the Memorandum of Association of Company as originally framed or as altered from time to time in pursuance of any company. So whenever in this context or in the Companies Act we talk about Memorandum of Association, the Memorandum of Association means the original Memorandum of Association, what was submitted at the time of incorporation of the company, or what was registered with the ROC time and time again whenever the MOA was altered. Now, which are the situations in which an MOA can be altered? An MOA can be altered when there is a change in name, when there is a change of address of the private limited company within the same state or from one state to the other, or there is any modifications of the objects of the memorandum, or there is a change in the authorized capital or some liability clause. So, whenever the company wants to carry out any activity that is not mentioned in the object clause of the Memorandum of Association, the company needs to modify or amend its objective clause to include that object, and then it can carry out that activity. Alright, so according to section 256 of the Companies Act 2013, the memorandum means the Memorandum of Association of a company as originally submitted, means originally at the time of incorporation of the company, or as altered from time to time in pursuance of any previous company's law or this act. Similarly, the Memorandum of Association is a document of great importance in relation to the proposed company, and it contains the objects for which the company is formed, and therefore identifies the possible scope of its operation beyond which actions cannot go. So this, if the activities of the company go beyond the activities mentioned in the object clause of the company, it is known as ultra vires the company. Okay, so this is what is about the little bit about the Memorandum of Association. So it is the most important document. It contains details about the important objects, the name, address, capital, liability, and subscription. Okay, and every person dealing with the company is expected to know the contents of the memorandum and AOA, and also should have understood the contents of the MOA and AOA. Please take a couple of minutes, go through this. Any questions, please ask me. Any questions, please ask me. Let me know once you're done, please. Any questions, please ask. Please take another minute. Any questions, please ask me. Take another minute, please. Are we done? Okay, let's move on. Now, the Articles of Association of the company are its bylaws. Now, we've discussed about what MOA is. Now, let's talk about what is the Articles of Association. The Articles of Association are its bylaws or rules, and regulations that govern the management of its internal affairs and conduct of business. So basically, whatever are the internal procedures, the rules and regulations, everything, they are contained in the document known as the Articles of Association. So like the Memorandum of Association dictates the external relationship of the company, the internal rules and regulations, the procedures and everything is contained in the document known as the Articles of Association, or the AOA as we call it. According to Section 2.5 of the Companies Act 2013, article means the Articles of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or present act. So, similarly to the Memorandum of Association, the Articles of Association, when we use the term in the Companies Act 2013, it also means the Articles of Association as originally registered at the time of incorporation, or the Articles of Association that has been altered from time to time and has been registered with the ROC for the purpose of giving effect to such an alteration. Now, what are the situations do you think that Articles of Association could be altered? It is when there is a company has received an investment, an equity investment from an external investor or a funding from another investor. That time the Articles of Association is altered because there are certain rights which the investor holds in his hands which he would like to incorporate in the Articles of Association, or there is a change in any internal procedures. Then the Articles of Association can be amended. The procedure for amendment of Articles of Association is simpler as compared to the procedure for amendment of a Memorandum of Association. So, the term Articles of Association will mean the document as originally registered at the time of incorporation or as amended from time to time and registered with the ROC. Both the Memorandum and Articles of Association are public documents according to Section 610 and 399 of the Companies Act 2013. These documents become public documents as soon as they get registered and can be accessible by members of the public under the provisions of the Act. So as soon as these documents are submitted with the ROC, these documents become public documents and anyone who is dealing with the company can obtain a copy of the same on payment of a nominal fee. Okay? The rule of constructive notice extends not merely to the memorandum and articles but also such documents as are required to be registered with the registrar of companies. There is, however, no constructive notice of documents which are filed with the registrar for the sake of record only. So, it's not only the memorandum and articles of association of a company but all the documents that have been submitted with the ROC for record keeping become public documents once they are registered with the ROC. But no other document other than the AOA and MOA are assumed to be of constructive notice. That means the other documents, there might be documents submitted for creation of charge, that is pledging of assets, or any special resolutions of the companies may have been submitted with the registrar, but those documents are not considered as documents of constructive notice, and the documents of constructive notice are only the MOA and AOA. Alright? So the rule of constructive notice extends not merely to memorandum and articles but also to all such documents as are required to be registered with the registrar of companies. There is, however, no constructive notice of documents which are filed with the registrar of companies for the sake of record keeping only. Okay, so there is assumed to be a constructive notice only for memorandum and articles and not all the other documents that are submitted to the ROC. Please take 2 minutes, go through this. Any questions you may have, please ask me. Any questions, please ask. Take another minute, please. Any questions you may have, please ask me. Carefully go through this. Any questions, please? Let me know once you're done, all of you. Please take another 30 seconds. Any questions, please ask. Let me know once you're done. Are we done? Okay. The effect of doctrine notice, constructive notice is harsh. Now we are coming towards the origination of why the doctrine of window management came into the picture. So we've understood the doctrine of constructive notice, right? So the effect of doctrine of constructive notice is harsh on an outsider who does business with the company. An outsider who dealt with the company is deemed to have constructive notice of the contents of the documents of the company, that is AOA and MOA. An outsider cannot claim relief on the ground that he was unaware of the powers of the company in case of ultra vires of the company. So in case the outsider enters into any transaction with the company without being aware whether the company is authorized to carry out the transaction or not, then he cannot use the excuse that he was not aware. He will be responsible for that. The doctrine of constructive notice is more or less an unreal doctrine. It does not take notice of the realities of business life. People know a company through its officers and not through its documents. Now please remember, when there's a person who's dealing with a company, the companies are giving orders to vendors and the vendors supplying the material and he's getting the payment. Over a period of time, the vendors build a rapport or a relationship with the officers of the company and they do not rely merely on documents. If the director of the company or the officer of the company just calls and says, hey Mr. Ram, please supply these materials and within a week I will make you the payment. Over a period of time, that kind of confidence builds up between the vendor and the company, and the vendors do not insist on documents. But suddenly, if someday their payment gets stuck and then the document is shown to them and said that, see, in the memorandum the object is not mentioned but you have been supplying materials for this, then, and because it is not there in the object clause of the memorandum, we will not pay you. Just imagine what will go through or what will happen to that vendor. That is why the doctrine of constructive notice is considered to be a little unreal. It's a little harsh on the outsiders. It does not take notice of the realities of business life. The courts in India do not seem to have taken it seriously though. For example, in Dehradun, Mussoorie Electric Tramway Co. versus Jagmandar Das, the Allahabad High Court allowed an overdraft incurred by the managing agent of a company when under the articles the director had no power to delegate their borrowing costs. So, in this particular case, that is Dehradun Mussoorie Electric Tramway versus Jagmandar Das, the Allahabad High Court allowed an overdraft incurred by a managing agent of the company, where under the articles the director had no power to delegate the power. So even though the articles the director could not delegate his powers in order to get an overdraft facility, but the court held that the overdraft facility that was taken by the agent of the company is allowed. Okay, so even the courts have given a bit of leeway to the doctrine of constructive notice. Please take 2 minutes, go through this. Any questions, please ask me. Please take 2 minutes. Any questions, please ask me. Any questions, please ask. Are we done? Please take another minute. Okay. Now, as criticisms of the doctrine of constructive notice, the new theory known as the doctrine of indoor management has been evolved by the courts. The doctrine of constructive notice needs to protect the company against the outsider. The other doctrine, that is the doctrine of indoor management, operates to protect the outsiders against the company. So now we are slowly coming to the origination of the doctrine of indoor management. The rule of indoor management is based upon obvious reasons of convenience in business relationships. Firstly, the Memorandum and Articles of Association are public documents open to public inspection. But the details of internal procedures are not thus known to the public inspection. Hence, an outsider is presumed to know the constitution of the company but not what may or may not have taken place within the doors closed to him. So basically, due to the inconveniences and the harshness of the doctrine of constructive notice, the doctrine of indoor management was originated, and this was originated by a lot of courts applicability as well. Now, even though a person dealing with the company is expected to know he is expected to know the contents of the Memorandum and Articles of Association of the company, meaning that what does the MOA have, what does the AO have, what is the company allowed to do and all that. But he is not presumed to have knowledge whether the internal procedures as mentioned in the MOA and AOA have taken place. For example, if there is a particular contract which needs the approval of 3 directors as per the AOA. Now that is an internal procedure. Now the vendor who is dealing with the company will not have access to the board meetings, right? So he can presume that the contract has been approved by 3 directors. He need not go and check and verify and satisfy himself whether 3 directors have approved it or not. He can very well assume that the internal procedures relating to the company's management as per the MOA and AOA have taken place. Okay? So, but the details of internal procedures are not open to public inspection. Hence, an outsider is presumed to know the constitution of a company, but not what may or may not have taken place within the doors that are closed to him. So, basically, the outsider knows the contents of the MOA, AOA, and what should the company do. But whether that has happened or not happened in regard to the internal procedure of the company, the outsider is not supposed to know that. Alright, please take 2 minutes, go through this. Any questions, please ask. Then we will go into the doctrine of indoor management in detail. Any questions, please ask. Please take 2 minutes. Please take 2 minutes. Let me know once you're done, please. Please take another minute. Any questions? Let me know once you're done, please. Okay, then the effect of the doctrine of constructive notice. Let's have a look at this. The effect of the doctrine of constructive notice or liability is harsh on the other party, that is the outsider who is dealing with the company. It is therefore the duty of every person dealing with the company to inspect its public documents and make sure that his contract is in conformity with their provisions. So public documents here we are referring to MOA and AOA. Okay. The Madras High Court discussed the scope of the rule of constructive notice in Kotla Venkataswamy versus Ramurthy. The dispute in this case was whether a mortgage bond was validly executed as per the company's Articles of Association so as to make the company liable. Article 15 of the company's Articles of Association provided that all deeds, hundis, checks and certificates and other instruments shall be signed by the managing director, the secretary and a working director. So it should be signed by the three people as per Article 15 of the Articles of Association of the company. In the instant case, the plaintiff accepted a deed of mortgage executed by the secretary and just give me a second, someone's at the door. Alright, sorry, someone was at the door. Alright, so as per this case law, Article 15 of the Articles of Association, any hundis, checks or any other promissory note has to be signed by the managing director, the secretary and the working director of behalf of the company and shall be considered valid. In the instant case, the plaintiff accepted a deed of mortgage executed only by the secretary and a working director only. The court held that the plaintiff could not claim under this deed. Court further observed that if the plaintiff had consulted the articles, she would have discovered that a deed such as she took required execution by the specified officer. So in this particular case, the court upheld that the person, the external person working with the company should have knowledge of the contents of the articles and memorandum and also should understand their meaning. So because the procedure laid down under Article 15 was not done, the court upheld that the plaintiff cannot claim under the mortgage deed because if she would have consulted the article, she would have known that it had to be signed by 3 people, but actually it was signed only by 2 people. So this was found to be a little harsh on the person who is external to the company. See, for you and like I told you, for you and me, it's easy to understand the legal language. But a person, a layman, let's say a vendor who's a hardware store guy, okay, or someone, it may not be so easy for him to understand the legal language. So he can read the MOA and AOA, but to understand the contents properly and only then do business, that's a very practical difficulty which a lot of people face. Alright, so this was the kind of practicality or difficulties that people were facing. Please take 2 minutes, go through this. Any questions, please ask me. Any questions, please ask. Please take 2 minutes, go through this. Any questions, please ask. Let me know once you're done, please. Please take 2 minutes. Let me know once you're done. Carefully go through this case law. Any questions, please ask me. Are we done? Carefully go through this. Let me know once you're done, please. Just give me a minute, I'll go to the washroom. Alright, are we done? Okay, so the company and she would have refrained from accepting a deed inadequately signed. So basically the court held that if she had read the articles of association and she saw that only 2 people have signed it instead of 3, she should have not have accepted it because the deed was inadequately signed. Notwithstanding, therefore, she may have acted in good faith and her money may have been applied to the purpose of the company and the bond is nevertheless invalid. One of the effects of the rule of constructive liability is that a person dealing with the company is considered not only to have read those documents but to have understood them according to their proper meaning. He is presumed to have understood not merely the company's power but also those of its officers. So this is one of the biggest drawbacks that came in, that a person dealing with the company is not only expected to have read the MOA and AOA but also assumed to have properly understood the company's powers but also its officers, which is not quite possible each time. If it's a person from a legal background or something, then it's easy, but if it's not, for a normal customer or a vendor, then it becomes a bit of a problem dealing with the company. So these were a few drawbacks of the uh, Doctrine of Constructive Notice. Any questions? Please ask me. Take a minute. Take a minute more. Any questions? Please ask me. Any questions? Please ask me. Okay, now let's look at the criticisms of doctrine of constructive liability and what led to the evolution of the doctrine of indoor management. The rule of constructive notice has proved too inconvenient for business transactions, particularly where the directors or the other officers of the company were empowered under the articles to certain powers, subject only to certain prior approvals or sanctions of the shareholders. Now, whether these sanctions or approvals have actually been obtained or not could not be ascertained, because in real situations, the investors, vendors, creditors, and other outsiders could not dare to ask the directors in so many words about those sanctions having been obtained or to produce the relevant resolutions. Okay, so like we discussed, that the doctrine of constructive notice or constructive liability had its own drawbacks. Okay, so for example, the whole company, let's say, is run by a board of directors, right? Now, as per the Companies Act, there are certain powers which the board of directors have, which they can exercise by themselves, and there are certain powers that the board has which they can exercise only with the prior or approval or consent of the shareholders. Now, for an external person, like an investor, vendor, creditor, and other outsiders, it is not possible to know whether the board of directors have taken the approval of the shareholders or not, and those outsiders dare not ask those board of directors that did you take the shareholders approval, did you take this approval, because then the board of directors could get offended, and if they get offended, then the outsiders, let's say they are vendors, they lose their business, right? So it was a very tough situation in practicality, and that was one of the biggest drawbacks of the doctrine of constructive notice. Since there are no means to ascertain whether necessary sanctions and approvals have been obtained before a certain officer exercises his powers, which as per the articles can be exercised subject to certain approvals with those dealing with the company, can assume, and if the directors or other officers are entering into those transactions, they would have obtained the necessary sanctions. This is known as the doctrine of indoor management. So as per the doctrine of indoor management, if the article says that the board of directors for so and so powers require the approval of the shareholders, and if the company undergoes that transaction, then the external people who have undergone that transaction with the company can safely assume that yes, the board of directors have taken the prior approval of the shareholders. They do not need to inquire more and get into it and find out whether the shareholders have approved it or not, take proof and all that. So now they can safely assume that the internal procedure regarding to taking of approval has been taken. And this was known as the doctrine of indoor management, and the leading case law for this is the Royal British Bank versus Turquoise, and that is why your doctrine of indoor management is also known as the Turquoise rule. Okay, please take 2 minutes, go through this. Any questions, please ask. Carefully go through it. Please take 2 minutes, go through this. Please take 2 minutes. Any questions, please ask me. Any questions, please ask me. Let me know once you're done, please. Take another minute. Let me know once you're done. Are we done? Okay, now let's look at the doctrine of indoor management in detail. Under the Indian law relating to companies, a public company is managed by a board of directors, which is entrusted with the responsibility of managing the company in the most efficient and transparent manner. So please remember, all the shareholders of the company, even though are owners of the company, but it's not possible for them to always run the company and manage the company. So a board of directors are elected by the shareholders of the company, who run and manage the company on behalf of the shareholders of the company. Doctrine of indoor management, popularly known as the Doctrine's rule, initially arose some 150 years ago in the context of the doctrine of constructive notice. The rule of the doctrine of indoor management is opposed to the rule of constructive notice. So, right, because of the doctrine of constructive notice itself, because of the criticisms of the doctrine of constructive notice, the doctrine of indoor management came into the picture. The latter seeks to protect the company against the outsider, and the former seeks to protect the outsiders against the company. So basically, your doctrine of constructive notice aims to protect the company from the outsiders, whereas your doctrine of indoor management aims to protect the outsiders from the company. It is on no part or duty of any outsider to see that the company carries out the requisite internal proceedings. So there are hundreds of internal proceedings and procedures as mentioned in the Articles of Association. So it is no duty of the outsider who is dealing with the company to make sure that such internal procedures or requisite internal procedures have been carried out by the company or not. Okay, and he can safely assume that the internal procedures, as mentioned in the Articles of Association, have been completed. But yes, he has to go through the object clause of the memorandum to find out whether the company is authorized to do that activity or not. Okay, please take 2 minutes, go through this. Any question, please ask me. Please take 2 minutes. Any questions you may have, please ask me. Any questions, please ask. Take another minute. Any questions, please ask me. Take another minute more, please. Any questions, please ask me. Carefully go through this. Any questions, please ask. Okay, let's proceed. Now, it is important to note that the rule of constructive notice can be invoked by the company and it does not operate against the company. It operates against the person who failed to inquire but does not operate in his favor. So, like we've read so far, that the doctrine of constructive notice protects the company from the outsider. That means it works in favor of the company and against the person who is dealing with the company. Whereas the doctrine of indoor management protects the outsider from the company. So, it works in favor of the person who is dealing with the company. Okay, the rule of doctrine of indoor management had its genesis in English case Royal Bank versus Turquand, and that is why it is known as Turquand's rule. In this case, the directors of the company were authorized by the articles to borrow on bonds such sums of money as should from time to time by a special resolution of the company in the general meeting. So basically, according to this case law, the directors of the company were authorized to borrow on bonds, that means issue bonds and borrow money from the public, but they needed a special resolution of the company in the general meeting. Special resolution means the resolution of the shareholders of the company be authorized to be borrowed. A bond under the seal of the company, signed by 2 directors and a secretary, was given by the directors to the plaintiff to secure the drawings of the current account without the authority of such resolution. So basically what they did, the board of directors borrowed the money, but they did not take the approval of the special resolution of the company in a general meeting. Then Turquand sought to bind the company on the basis of the bond. So they issued a bond to Turquand. Okay, and it was signed. It was signed by the directors and the secretary of the company, but without the special resolution required by the Articles of Association. Thus, the question arose whether the company was liable on that bond. Now, the question was whether Royal British Bank was liable on those bonds because they did not follow the internal procedures as given by the Articles of Association. The Court of Exchequer Chamber overruled all the objections and held that the bond was binding on the company, that is Royal British Bank, as Turquoise was entitled to assume that the resolution of the company in the general meeting has been passed. So basically here, this was a leading case where the concept or doctrine of internal indoor management was upheld by the court, whereas otherwise it became very easy for the company, right? The companies will take the money and everything. When they have to repay, they'll say, no, it required a special resolution. The resolution itself was not taken, so it was an invalid thing. So, to protect the outsiders from the company, the doctrine of indoor management was introduced, and this was the leading case. Turquoise was British Bank versus Turquoise. So, the court upheld that the bond issued by the bank, even though without the approval of the shareholders, was valid, and Turquoise was entitled to claim on that. Please take 2 minutes, go through this. Any question, please ask me. Any questions, please ask me. Please take 2 minutes. Any questions you may have, please ask me. Let me know once you're done, please. This is an important case law, so you need to know this. Any questions, please ask. Let me know once you're done, please. Okay. Well, now we have the exceptions, that which are the cases in which the doctrine of indoor management does not hold good. These are the 5 cases when there is knowledge of irregularity, so that when the external person who's been working with the company had the knowledge of the irregularity happening in the internal procedures of the company, but still goes ahead and does a transaction with the company, then he cannot take the excuse of doctrine of indoor management. The second one is negligence on the part of the outsider. So if the outsider dealing with the company had a slightest of idea that there is something wrong with the internal procedure of the company and maybe I should find out, and he could have found out with a little bit of due diligence, but he fails to exercise that due diligence, then in that case, if something goes wrong tomorrow, he cannot claim under the doctrine of indoor management. Forgery means fraud. If there is any internal procedure that has been done by fraud in the company, then the protection under doctrine of indoor management is not available. And if the external person dealing with the company had no idea at all about the knowledge of the articles, that is also not an excuse, because they being the public documents, he should have at least gone through the articles of association, if not anything else. And if the internal person in the company acts outside the apparent authority, so the internal person of the company, while acting or entering into a contract with the external person, did not actually have an authority to enter into the contract, then in that case, the doctrine of indoor management cannot be taken support on. Okay, please take a minute, go through this. Any questions, please ask. Any questions, please ask. Take about 30 seconds more. Okay, so now here are the things in detail. A knowledge of irregularity, where a person dealing with the company has actual or constructive notice of the irregularity as regards internal management, he cannot claim the benefit under the rule of indoor management. The leading case is TR Pratt Bombay Limited versus ED, Sassoon and Co Limited. Company, in this case, the company A lent money to company B on the mortgage of its assets. The procedure laid down in the articles for such transaction was not complied with. The directors of the two companies were the same. It was held that in the case that the lender had notice of the irregularities and hence the mortgage was not binding. A transfer of shares in a company was approved by two directors. One of these directors was not validly appointed. The other was disqualified by reason of being a transferee himself. These facts were known to the transferor. So in both the cases, you see these case laws, the facts of irregularities were known to the external person. It was held in this case that the transfer of shares was ineffective. So the case of doctrine of indoor management cannot be relied upon. Please take a minute, go through this. Any question, please ask me. Please take a minute, go through this. Any questions you may have, please ask me. Let me know once you're done, please. Carefully go through this. Take another minute, go through this. Let me know once you're done, please. Are we done? Okay, negligence on part of the outsider, where a person dealing with the company could discover the irregularity if he had made proper inquiries. He cannot claim the benefit of the rule of doctrine of indoor management. The protection of the rule is also not available where the circumstances surrounding the contract are so suspicious as to invite inquiry and the outsider dealing with the company does not make a proper inquiry. If, for example, an officer of a company purports to act outside the scope of his apparent authority, suspicion should arise and the outsider should make proper inquiry before entering into the contract with the company. I've explained this point to you. So wherever the external person gets a little bit of doubt that something is not okay, he should make proper inquiry, and if he fails to do so, he cannot claim benefit of the rule of indoor management. Forgery. The rule in Turkwan's case does not apply where a person relies upon a document that turns out to be a forged one, since nothing can validate forgery. A company can never be held bound for forgeries committed by its officers. So, a transaction which is by fraud or forgery can never be held on the company. So, the benefit of the rule of Doctrine of indoor management cannot apply in such cases as well. Please take a minute, go through this. Any question, please ask me. Any questions, please ask me. Let me know once you're done, please. Okay, and then the last point, acts outside the apparent authority. If an officer of the company enters into a contract with a third party and if the act of the officer is beyond his authority, the company is not bound. In such a case, the plaintiff cannot claim the protection of the rule of doctrine of indoor management simply because under the articles, the power to do the act could have been delegated to him. The plaintiff can sue the company only if the power to act has in fact been delegated to the officer with whom he has entered into the contract. So basically, if the officer of the company who has entered into the contract with the outsider was not even delegated with that power and authority to enter into the contract, but he still went and did it, then that particular act does not bind the company against the outsider. Okay, so the outsider cannot take advantage of the doctrine of indoor management. Please take 30 seconds, go through this. And then we proceed. Any questions, please ask me. Let me know once you're done. Okay, so if you're done, we will be ending this session with that. So that was your doctrine of indoor management under the Companies Act 2013. So please do not forget to use the code Prathik to get an instant discount when you make your Plus subscription. Thank you so much for being a wonderful audience. And once again, I would like to welcome you to Crack CA Exams with us, which is a vertical and channel of Unacademy that caters to the students of CA Foundation and Intermediate in their journey and pursuit of preparation for the CA Foundation and Intermediate examinations by providing top educators, quality content, and overall a great learning experience. So come, let's crack CA exams with Unacademy, India's largest online learning platform. Thank you for being a wonderful audience. I hope you found the session useful. After going through this session, in case you have any questions, queries, or anything, observations, you can always feel free to write to me. And please do not forget to get onto the Unacademy Learning app, go to my profile and click on the follow button to get real-time updates about the timings and topics of my session. Thank you so much and have a great day, and I have a special class in the next 20 minutes on the Unacademy Learning